Hello, my name's Peter Dodge and I'm a barrister at Radcliffe Chambers, and I'm joined today by Cecily Crampin, who's also a barrister at Falcon Chambers, for this LexisNexis residential property webinar entitled Mortgages in 2018. So the webinar will, we hope, be of interest to anyone practicing in the field of mortgage law, whether they're acting for lenders, receivers or borrowers. And I'm going to be speaking about two cases. First, a decision of the Supreme Court in February, Enram and Steele. It concerns the release of a mortgage, but it also considers issues of wider application, in particular whether a party is entitled to rely upon what it's told by another party's solicitor. And an even more recent case, a decision of the Court of Appeal at the end of March, Fortwell Finance and Halstead. In that case, the borrowers asserted that a mortgage was unenforceable. They said it was a regulated mortgage contract for FSMA regulatory purposes, and the lender wasn't authorised. So, Cecily, what are you going to be talking about?
So, I'm going to talk about deemed agency in mortgage receivership. There's been an increase in use of receivership in the residential context since the buy-to-let market opened up. And the key to success in cases involving mortgage receivership is to understand the receiver's powers. The key to success in understanding the receiver's powers is to understand the deemed agency, which governs where they come from. I'm thus going to talk you through the deemed agency and the case law, and in particular explain why deemed agency for receivers is not like agency as we normally think about it.
So, the 3 R's: redemption, regulation and receivers. We look forward to you joining us for this webinar.